So welcome everyone to this morning's session, In-House in Focus. For those of you who don't know me, I'm Jayne Hussey. I'm a partner here in Mills Reeve and I specialise in commercial contracts. I also lead our In-House in Focus programme. Today, I'm joined by Tom Filby, who is one of our specialist insurance partners. And today we're going to be looking at the supply of services, liability in the context of the supply of services, and how that interacts with insurance cover that your organisation may have in place. Some of you will remember that a few months ago, Tom and I ran a similar session, which was focused on the supply of goods, liability and insurance. And many people at the end of that session gave us feedback that they wanted us to run a similar session in the context of services, liability and insurance. So here we are today running that session. Now, just before we move on, I wanted to raise very quickly a completely unrelated subject, and that is the subject of sanctions. All law firms very recently received a notification from the SRA reminding us of our professional duties with respect to sanctions and sanctions advice. And I asked the question, have our in-house lawyer community received a similar notification? And I was assured by the SRA that indeed the in-house community has received similar sanctions information and notifications in the context of professional duties. So I'm raising this just to comment that if you have received something from the SRA and you haven't had time to digest it, please make sure that you do, because it is a useful reminder of our professional duties in the context of sanctions and sanctions advice. And if you don't think you have received that notification, have a look on the SRA website, because you should be able to find it there. But that's all I wanted to say on that. Back to today's webinar. So a few housekeeping points. As always, this webinar will be recorded, and a link to the recording and the slides will be sent to you in a few days' time. And the recording will also be available on our In-House in Focus hub, which is on our website. If you have questions, please put them in the Q&A box at the bottom of your screen. Only myself and Tom can see those and see your name. So if you don't make yourself anonymous, it means that if we don't get to your question, Tom and I will be able to follow up with you afterwards. And then finally, as I always say to you, feedback is really important to us. So as we close this session, a short feedback screen is going to pop up and it will help us shape future sessions. So please do give us your feedback. As I said earlier, this session was born out of feedback that was given to us a few months ago. So just turning now to the agenda, the way we're going to run this morning is Tom is going to kick off by looking at some of the different insurances that may be relevant to your organisation in a services scenario. And what we will then do is we're going to look at an example clause. I'm going to pass some comments on that clause from what I call a mainstream commercial contracting perspective. And Tom is then going to pass observations in the context of insurance and how the obligations and liabilities in those clauses might talk to insurance cover that you may have in place. We'll then finish off with dealing with your questions, and we will aim to be finishing within the hour. So without spending any more time, Tom, can I pass over to you, please?
Excellent. Thank you very much, Jayne. Good morning, everyone. As Jayne said, I'm an insurance and disputes resolution lawyer at Mills Reeve. I regularly advise on policy coverage issues following claims and losses, generally within the corporate and financial line sphere. Also undertake policy reviews for some of our corporate clients. Jayne mentioned that previously we'd looked at insurance in the context of the supply of goods, and that was with a particular focus on liability insurance, which seeks to protect businesses against liabilities in respect of third parties. We'll have a similar focus today, liability insurance, but this time looking instead at supply of services. Next slide, please. There is a huge array of different types of insurance covers available, ranging from single SME focused policies that seek to consolidate many covers under one roof, right through to single risk and transaction specific ones. The insurance covers that you seek out and how you choose to structure them within your business will very much depend on the nature of your business and the manner in which you engage with your customers. And ultimately, you should seek advice from an experienced broker as to how you should do all of this and what policies you need. I have, however, set out on the slide some of the types of insurances that you are likely to consider as a supplier of services and indeed goods as well, and likely you probably do both. The next slide comes on to provide a short description around some of the key insurances that may be of interest to you. So I would say that, like with the supply of goods, a key policy for a supplier of services is likely to be public liability. And this covers you in respect of physical injury caused to third parties or damage to their property arising in the course of carrying out your business and services. This will generally relate to the physical and tangible aspects of supply of goods or services, such as the manual installation of equipment. But more so than with goods, in respect to the supply of services, there can also be a more intangible aspect where the service can represent what one might term expert advice, consultancy to the clients or customers, or a design advisory elements as well. And this could, of course, be something that you do alongside the supply of goods, alongside their installation. And the case of Trebor Bassett and ADT Fire is a good example of this, I suppose, supply and goods mix. Trebor produced popcorn, which, believe it or not, is a very hazardous and dangerous activity. And they engaged ATD to design and supply a bespoke, tailor-made fire suppression system that would be discharged upon the first detection of a fire. Unfortunately, the system never did that, and the Trebor factory burned down to just a few husks and kernels. It was asserted in the course of the matter that it concerned the supply of goods, and in turn the fitness and quality and other terms that are implied under legislation where goods are concerned. But the court disagreed and found that ADT's responsibilities and liabilities flowed from the supply of design and installation services, and not the supply of goods, even if ADT goods were supplied within the context of that service. Now, this sort of distinction, it may seem sort of legal and academic, but in fact, it can be highly relevant, not just to the nature and extent of legal liability, where supply of goods and services are subject to different fault-based terms, but also to policy coverage. So product liability insurance for goods may well cover damage to other property caused by products that have been supplied, but it's less likely to cover injury or damage arising from the misconceived design of a product or of a system. Those aspects might instead be regarded more as a professional liability matter. And I'll come on to this in a second. What this case does is effectively highlights the importance of considering very carefully as a business what services you are supplying and how you're doing that, and what understanding you have with your customers. If ultimately the service represents expert advice, consultancy, or design, or there's a risk that clients might in due course allege that this is what you're doing, then you might want to look at other types of insurance, such as professional liability, as being key to protecting your business. And this is where the supply of services, it enters this kind of almost uneasy world and interaction with professional liability insurance, which doesn't always fit easily when you're looking at businesses that are perhaps not strictly professional services businesses. This type of insurance, professional liability, has historically been the preserve of traditional professions, such as lawyers, accountants, surveyors. And over many years, the courts have developed guiding principles around what constitutes a professional. And ultimately, that's quite narrowly drawn. But increasingly, insurers are making available, because of the demand for it, insurance of this type that's now occupying a space by businesses that are providing advice or consultancy services, but go beyond what the court and the law might typically regard as, quote, professional. So this can range from fitness coaches, where they're providing advice and guidance to their clientele, through to security systems and suppliers that are effectively, a bit like with ADT and Trebor, developing systems to protect their clients, and in respect of which financial losses can arise if they don't work. Some professional liability policies provide narrow cover at the outset in respect of just negligence, whereas others can provide a broader civil liability cover that it can encompass a much wider range of wrongful acts, and it relies on extensions to narrow that scope of cover. You can even find within this type of liability cover, cover that extends to unintentional breaches of confidentiality, loss of information. You've got defamation and breaches of IP rights as well. So it's worth exploring with a broker what insurance is available out there, and importantly, to consider whether there are aspects of your business that maybe stray beyond mere straightforward supply of services, or indeed the supply of goods. Are you entering that sphere where you are potentially acting a bit like a professional or an expert, and you might well need a different type of cover, like professional liability? Next slide, please. When looking at determining whether there's cover under a particular policy, we spoke about this at some length during our last talk in the context of supply of goods, and we delved into some detail around legal considerations, such as the need to establish an actual legal liability in order to recover, how it's the true nature of the claim or loss that matters from a policy coverage perspective, and not merely how a claimant may have chosen to frame it and pursue it before a court. Also, the principles around allocation of so-called dual purpose costs, where part of a claim is covered by insurance and part is not. Don't propose to go through these in detail, but you can pick up those points if you wish from the recordings of the previous webinars that are available on our website. But one of the key points that did want to elaborate on, and which continues from what we discussed around supply of goods, is that liability insurance cover is concerned with those liabilities that arise and exist outside of contractual terms, so tortious liabilities. In many instances, a shortcoming in the supply of goods or services will probably straddle both a tortious and contractual liability concurrently. So, for instance, you've got Section 13 of the Supply of Goods and Services Act that implies a term into any relevant contract that a supplier will carry out their service with reasonable skill and care. Now, that reflects in a similar duty to act with reasonable skill and care under common law, when one party assumes a duty to another. But where you have a situation where the liability is of a purely contractual nature, so it goes above and beyond the duties of common law, then the likelihood is that the liability will not be covered by your insurance policy, whether it be product, public, or professional liability insurance. An issue related to this is what you might say fitness for purpose in respect of products, and in respect to the supply of services, guarantees and warranties that a service to be supplied will achieve a particular result. Now, these are at risk of imposing a higher duty than that which exists at common law, which is only concerned about whether the person providing the service has exercised the requisite level of skill and care, not whether or not a particular specified result has ultimately been achieved. As I mentioned a moment ago, most liability policies will not cover purely contractual claims. So, for instance, for breach of fitness for purpose or failing to hit a specific outcome specified in the contract. So this naturally leads to a need to balance the desire to negotiate rigorous contractual provisions with clear and specific objectives and outcomes, with a desire to ensure that all key liabilities arising under the contract with your customer has the benefit of likely insurance cover sitting behind them in the event that something goes wrong. And these types of issues, they lead neatly on to what Jayne will now go through in respect to some of the typical liability clauses that we come across in supply contracts. And I'll then, alongside Jayne, take a look at how insurance may speak to these.
Thanks, Tom. So what we're going to do now is look at an extract from a services contract. This is something we've seen recently, obviously anonymised and adjusted slightly. Kate, could I have the next slide, please? Thank you. So the services contract is drafted to be pro-customer, and we're advising the supplier. Under this services contract, there are going to be long-term installation services. So the supplier is retained on a long-term contract to perform some installation services. I should comment that the installation services are not construction or construction-related services. And that is an important point to make, because when you get into the world of construction, you're opening quite a different can of worms in terms of considerations and in particular insurance cover. The clauses we're going to look at are the quality assurance clauses, the insurance clause and the liability clause. So let's turn to the quality assurance clause first. Like I say, I'm going to pass some observations from a general commercial contracting perspective and then ask Tom his views in the context of insurance. So here you can see that the supplier is obliged to provide the services and the deliverables in accordance with Schedule 1. Schedule 1 being a service specification and the deliverables being particular outputs from the services. So, of course, the first thing I would do is be talking to the supplier about very carefully reviewing that service specification and the deliverables to ensure that they are satisfied that they can deliver in accordance with those. I would also, the supplier, have you made any assumptions in agreeing to that service specification? And do you have any dependencies on the customer in order to enable you to deliver? So you may require, for example, the customer to take certain preparatory steps to enable you to deliver the service. So that would be one of the first things I would be talking to the supplier about. The other thing I would be talking to the supplier about would be actually what is the acceptance regime that needs to be followed. So the regime by which the customer will review the services and the deliverables and sign off that they do meet the specification within certain timeframes. So those that would be the sort of discussion points around Lim A. Tom, presumably from an insurance cover perspective, there is a piece around assessing the services and deliverables in the context of insurance coverage. Would that be a fair thing for me to assume?
Absolutely. I mean, it's in part it goes back to the point as to being clear about what services are being specified contractually and what is in reality going to be provided. That Trebor case highlighted how there can sometimes be some doubt or arguments as to the true nature of the services you're supplying. And that, again, sort of outside of an insurance perspective, can have some big material impact upon liability, claim liability, and loss liability issues, but will also impact upon the nature of the insurance that you could be relying on to dig you out of a hole. So I think careful thought needs to be given to what is effectively being promised through those services, and whether it strays into areas such as advice or consultancy services that are perhaps not intended, or are not key part of your business, or are not currently backed by, let's say, professional indemnity insurance.
Yes. You raise a good point there, because indeed my team has worked with your team in the context of a business that inadvertently strayed into giving some advice purely to try and be helpful to their clients, and suffered a liability as a consequence. So they were giving advice almost on a goodwill, trying to be very helpful basis, and ended up with a liability as a consequence. So a really good point there. Just looking at Limb B, I mean, we've got a duplication. The first thing I would be saying here is there's a duplication between the first part of B and actually A, because you've got the services and deliverables conforming with Schedule 1. So I would be looking to amalgamate those. But the other points I would be looking at here is ensuring that the services and deliverables conform with the supplier's tender response. Now, we all know that people say all sorts of things in their tender response that perhaps they don't intend to be binding. So I would be looking to remove that, or at the very least make sure the supplier is comfortable standing behind everything they say in their tender response, because of course you may have a contractual liability, but you may also have a misrepresentation liability. The other piece here I would be looking at is the deliverables being fit for purpose, because I think the question is well, who has assessed what fit for what purpose, and who has assessed that? So the question being, well, actually, has the customer selected the services and the deliverables outside of any input that our client, the supplier, has had on this? So I would be looking to dig a lot deeper into that fitness for purpose requirement. Tom, how does fitness for purpose speak to insurance?
It's, I mean, this is a difficult area. I touched upon it earlier. So, I mean, there is no problem in principle for the parties agreeing that they're trying to get to a particular place. I mean, obviously, everything is about outcomes and aims. Where the difficulty arises with insurance is if a party to a supplier is effectively warranting that they will achieve that desired result. As I mentioned earlier, what the duties of care that exist outside of contracts are not focused on what the ultimate result necessarily is, or at least not around guaranteeing that result. As long as you have exercised reasonable skill and care in the course of seeking to achieve that goal, that's sufficient from a tortious perspective. And it's in relation to that level of duty of care that liability insurance will respond. So it will cover you for negligence in having failed to exercise reasonable skill and care, which also resulted in not getting the desired outcome. But what the insurance will not do is respond to situations where, let's say, you have exercise reasonable skill and care in the deployment of your services, but for whatever reason, you have not achieved the stated deliverable. So you're in breach of contract, but you're not in breach of duties outside of that. And that's when there is likely to be a gap in your insurance cover. So that obviously thought needs to be given as to how fitness for purpose is being, I suppose, agreed in the course of agreeing contractual aims and outcomes.
Thanks, Tom. I mean, I think you're raising a really good distinction that people ought to bear in mind all of the time, which is the tortious standards versus, tortious liability versus the contractual liability, really. LIMSI, performing the services with the highest level of care in accordance with best practice in the suppliers industry. And here from the commercial perspective, I'm sure everybody on this webinar is recognizing these are really subjective elements. What is the highest level of care? What is best practice? So from a commercial contracting perspective, we would want to be curtailing that. And depending on the nature of the services and the nature of the customer and supplier relationship and so on, actually I would be looking to eradicate C and say, well, actually the specification is the specification. And that's what we are agreeing to. But obviously, this is all very sort of circumstance specific. Looking at Lim D, this is the deliverables, the outputs. There is the requirement that goods, materials, standards, techniques are of best quality, free from defects in workmanship, installation and design. There's a few things I would be asking here. Aside from this, the best quality and the completely free from defects, which would be, well, actually, what extent are you reliant on, for example, information or materials that your customer is providing? Because we will often have supply arrangements where the customer is providing an element of the materials, or the customer is stipulating where the supplier must get the materials from. And in those circumstances, I would be saying, well, why is it reasonable and fair that we underwrite materials that you are supplying or stipulating the source from? Obviously, best quality, very, very subjective. So we would be looking to curtail and caveat that. But Tom, I'm interested in your perspective on this free from defects in workmanship, installation and design. I mean, again, we would be looking to caveat that potentially in terms of free from material or, significant defects in workmanship, installation and design to try and avoid minor inconsequential failings being a sort of cause of action for the customer. But what's the perspective in the context of insurance?
I mean, there's I suppose a number of points. I mean, looking at the free from defects, I suppose ultimately that's I suppose, yeah, free from defects in the sort of supply aspect. I mean, you've got it in relation to goods, where again, defective goods in themselves, unless they cause damage to others or other property, will not fall within the scope of product liability. You need a product guarantee policy to do that sort of thing. And I mean, effectively saying something free from defects in relation to workmanship, installation, design. Well, it's firstly, again, are you making a statement providing a warranty or a guarantee as to a position that goes beyond what, and in the same way to fitness for purpose, you're guaranteeing a particular outcome, which again strays from the common law duties. But then you've got issues as well in relation to workmanship. So typically that will not be covered under just sort of standard professional indemnity policy or other liability cover, and you'd need to seek special extensions of cover typically, or policies for workmanship. And you've got contractors or risk insurance that will often provide that sort of cover. But yeah, so firstly, workmanship can catch a lot of sort of people out in terms of insurance. Do you have cover for that? Do you need cover for it? In relation to sort of installation, again, similar issues to workmanship, where if the installation effectively causes damage to, let's say, the product that you are installing, that's potentially not deemed to be damage to other property for the purposes of triggering liability cover under public liability or product liability insurance, for instance. So again, just think about the context in which you are operating as a business you are installing, and consider the insurance that you have and whether it would apply to those specific scenarios that you can envisage where losses and risks arise. And design, again, if it's in there, are you actually providing design services? Do you want to give the impression contractually that that is part of what you're doing? Because that potentially moves you into the sphere of not just supply of services, but supply of expert or professional advisory design services, that then becomes more of that professional liability risk. And if you are doing that, then be aware that you're doing that, and look with your broker at professional liability insurance if you don't already have it.
Okay, thank you. Kate, could we have the next slide? We've got an assurance here that the supplier is complying with all applicable laws for services, installation, use of equipment. And one of the immediate questions I would be looking at is actually how applicable laws are defined, because quite often we find that actually they aren't just defined by reference to statutory statutes, but actually can encompass codes of practice. So that definition is very relevant here. I'd obviously be looking to talk to the supplier as to, well, actually, where are you performing these? Because it becomes particularly relevant if they're performing services outside of their home territory. Tom, any observations in terms of geographical coverage of insurance policies?
Yeah, so typically, again, with liability policies, they will respond on they respond to claims, let's say, rather than typically sort of incidents. And what becomes a sort of key determining factor then is where the claim is being brought, which might well be different to where you think you're providing services. It might be that sort of another party within the supply chain has performed services in another jurisdiction, and that's where the loss arises, and somehow it comes back to you. So you need to be thinking about all the jurisdictions that you are potentially exposed to, whether directly in relation to your own sort of aspects of the supply chain, but also where you might be exposed to as a result of others within that chain. Typically with policies, I mean, it's all down to what you seek. There will be different premiums payable for different scopes of geographical cover, but a lot of the time, I mean, you'll either have UK cover or, quite frankly, it'll be worldwide cover, which is, I think, is prudent if you've got any overseas aspect at all. And again, as I said, that will typically respond on a claims basis. As to the actual applicable law, that is not so important. It's more around jurisdiction, so where you're being sued, for instance. Or one thing to note is, even if you have worldwide cover, typically claims in the US or Canada will be excluded. And that simply reflects the very significant costs of litigating or defending claims in those jurisdictions. So insurers will typically require you to purchase an extension of cover in relation to those territories if that's what you're looking for.
Sorry, I lost you for a moment, and I don't know if it was my internet or yours, Tom.
No, I think that was mine. Sorry, apologies.
Don't worry. F, very quickly, we've got observing health and safety rules and security requirements at the customer's premises. So I think there's probably a piece there around the health and safety, the insurance angle there, Tom, and health and safety risks to employees, and also what the customer's sort of security requirements are. Just moving on to G and H, these are both one and the same point, really. Holding customer materials at their own risk and holding customer equipment at their own risk. And one of the questions I would be asking here is, well, actually, what are the materials and the customer's equipment, and where are they going to be located? Because it would strike me that you're holding it at your own risk, but if actually they're located on the customer's premises where you don't have control of security, that may be problematic. But Tom, in the context of insurance, is it possible to insure third-party product when it is located on a third-party site, as is contemplated by G and H?
Yeah, I'd say this kind of stumped me slightly. There's always insurance for everything if you're prepared to negotiate and pay for it. I mean, I think it's not something that I've come across. I think there's obviously cover out there, whether it be sort of under public or product liability or even professional indemnity, where a third party's property, a customer's property, is let's say sort of protected in respect of damage that you might cause. But in relation to actually safeguarding that property effectively as if it was your own, then I think you're looking more at probably a first party type of cover where you're trying to bring that property within the scope of your own stock insurance or whatever it might be. And that potentially is more problematic, particularly if it's on third party premises. So it's I think that would be one I would respectfully defer to a broker. But yeah, I think it's okay. I would be wary about agreeing to effectively be responsible for another party's. I'd probably assume that you're not going to have insurance cover for that.
Yes. Okay. Next slide, please, Kate. So let's, again, very typical insurance clause that we see in these type of contracts. And you'll see here that there is an obligation on the supplier to hold insurance, not just during the continuance of the agreement, but for 6 years afterwards. They're asking for PI insurance of 10 million, public liability of 10 million. And interestingly, the language to cover liabilities that may arise under or in connection with this agreement. And then the final part of this clause actually asks the supplier to make the customer an additional insured. So from a mainstream commercial perspective, I would be looking to ask the question about the 6 years post termination, because naturally that is very costly, and query whether it is necessary. I would be looking at the insurance levels to verify that the supplier has them. Interestingly, you can see the amounts, but it doesn't say whether those are per annum or per claim or series of connected claims limits. So we would want to look at that. The language to cover the liabilities that may arise under in connection with this agreement, I would be looking to remove, because as Tom has very clearly explained, you can't hold insurance to cover every liability under the agreement, or indeed, if you can, actually commercially, it will be completely unacceptable in the context of pricing. And then the final point I would be raising would be, look, the customer can ask to be an additional insured at any point, and there will be a cost to that. And you probably haven't factored that cost into your pricing. So those are the sort of observations I would make. But Tom, what observations would you make if you were presented with this clause?
Probably very similar ones to you. I think I mean, the requirement to hold insurance, that's absolutely fine. I think, I mean, as I said at the very start, I think you can have insurance for specific projects. And if in fact this is a long-term supply of services contract over a significant period of time for significant revenue, then you might consider that it's worthwhile investing in a specific one-off policy for this particular contract or this project, and particularly where jumping to the final sentence where it talks about the supplier having the customer's interest being noted on the policy. Certainly I would not expect a customer to be an additional insured. That throws up a whole heap of issues for insurers around I mean, who's making the recovery, who's entitled to recover, who's been making declarations as to the nature of their business and making fair presentation on the risks. I think at most you would have a particular project or a particular customer brought to insurers' attention. And again, the best way of doing that would be a single risk project policy. But even without that, it's fine. I mean, I think, again, avoid, I mean, assume that you can't insure for all liabilities under the contract. So again, it will be on that tortious basis. You can note the customer's interest, but I would be reluctant to sort of go any further than that. And again, chat with your broker as to whether you can find an insurer that would be available to structure things in a different way. And in relation to maintaining the cover, again, it's just think about, I mean, it's if you're renewing your cover, if this is not a one-off risk that you're insuring, one-off policy, you need to think that every single year you'll be renewing it. You may need to bring to insurers' attention particular circumstances that may give rise to a claim, particular issues, particular contracts, and there's no guarantee that you will always get a renewal that will cover. If you've had a problem on this project, for instance, you might find that all insurers say, well, we're going to include a specific matters exclusion. We'll renew your cover, but we'll exclude anything relating to this project because we just haven't got the appetite for it anymore. It's too risky. So then you find yourself in breach of this provision. So again, it's a commercial call. It's difficult. You can never anticipate really what happens in the future. I think, I mean, in relation to the sort of 6-year period, I mean, that you can, I mean, there are different ways of looking at this. You can obtain runoff cover for risks for a period of time if your business ceases after you've entered into this agreement, or if you want specific runoff for a particular risk. Again, you can look at that sort of thing. But there are, I think you need to be very clear about what your insurance program looks like and how you expect it to run for the foreseeable future before you start agreeing to effectively, say there will be insurance cover. It's not within your gift to issue insurance.
Yeah. Thanks, Tom. Okay, let's turn to our final clause, which is liability. So, Kate, if you could move the slide on for me. Structured in a fairly typical way, where it starts with the areas where you are not limiting your liability. Most of these fairly standard. The TUPE obligations, obviously, we would be looking in detail at the TUPE clauses and the TUPE responsibilities and consultation requirements, and typically you'd find TUPE indemnities as well in those clauses. But there is an interesting piece here around, for example, health and safety claims that arise pre-transfer but are made post-transfer. So, Tom, how does that speak to sort of health and safety type claims and insurance cover?
Yeah, I mean, in relation to, I mean, slightly different sort of things, I suppose, with TUPE, where you've got, so if you've got an employee that's suffered an accident, and then they're TUPE'd onto a new employer, Now that new employer will assume that liability for that accident to the employee, but the way that the legislation and the case law has evolved effectively suggests, I think whether it goes as far as making it absolutely clear, it suggests that it will be that the new employer is entitled to effectively call on the insurance of the previous employer to indemnify in respect of that loss. There are some sort of grey areas around that. I mean, one issue to bear in mind is, if you're the new employer, do you know what the previous employer's insurance terms of their insurance were? So if they're carrying a very significant policy excess that needs to be discharged as part of any claim, I mean, quite frankly, who picks up the tab for that? I'm not aware that there is clarity on that particular issue. So it's important in that sort of sphere to understand what the sort of almost predecessor employers' arrangements are. And then very briefly on health and safety generally, I mean, sort of putting to one side TUPE, I mean, it's health and safety investigations, regulatory investigations can be a real problem for businesses and for their managers, their directors and officers. And it's whilst fines and penalties issued by regulators are generally uninsurable at law for public policy reasons, the costs of regulatory investigations can be pretty huge. And so as a business, you'd be looking to protect yourself against those with directors and officers, so D&O liability insurance, and potentially alongside that corporate legal liability insurance as well. So it provides cover for defence costs for health and safety and other regulatory incidents and investigations.
Smashing, thank you. So let's turn to the next clause, which is 2.2. And this is a series of caps. So we've got a damage to property caused by negligence, a cap per event or series of connected. We've then got a data protection liability cap, and then we've got a sort of catch-all for everything else. So a couple of points on 2.2, sorry, is other than in Lim A, there isn't reference to liabilities arising in tort, breach of contract or otherwise. So I would be looking to amend the start of 2.2 so it is clear that the caps apply regardless of whether the claim arises in contract, tort or otherwise. That's a key point. Damage to property caused by negligence, Tom. Any observations from an insurance perspective there?
Again, it sort of depends whether it's, I suppose, property that you're working on, as it were. So again, it comes back to that principle of liability insurance. Tortious liabilities respond to damage to other property or damage to other persons. So need to think about, we need to determine what property we're talking about. And that's not always straightforward, particularly where you're working on sort of a component within a bigger property. Is it all kind of one and the same property that's being worked on, or do other components of the same bigger piece represent other property? So there can be some sort of legal debates over that.
Okay. Then we have the data protection limb, which obviously we would need to look at in the context of both the data protection, the substantive data protection clause, and actually the practicalities of the personal data passing and who is doing what and so on. An immediate point here is it is not clear whether that cap is a per claim cap, an annual cap, or a life of contract cap. So I would be looking to clarify that. But Tom, how does data protection talk to potential insurance cover?
Yeah, again, it's available out there in different forms. So if you're carrying professional liability insurance, then typically, if it's not limited purely to kind of negligence, acts, errors, or omissions, it will extend to data breaches as well a lot of the time. Again, with limitations, it can be quite narrowly drawn, and it might be that actually you need to turn to a cyber policy instead. Consider again whose data you're handling, how you're handling it, where it's being stored, the extent to which you're doing that, and maybe even projections around the type of the extent of the loss that could be caused, how sensitive is that data, and then consider what type of insurance you need to cover that. I mean, one thing I'd also add just around within this clause, I mean, the limits, the sort of the caps on liability. You can often get sub-limits. So you have your sort of, let's say under professional liability policy, you have maybe sort of 1 million or 10 million pounds worth of cover, but then other for the main sort of negligence cover. But then if there's an extension in relation to loss of documents or breach of confidentiality as an extension of cover, those may be sub-limited to potentially sometimes just costs of dealing with claims rather than compensation. But if it's compensation, it might be sub-limited to a lesser amount than the overall cover, and that you might need to have regard to that when thinking about what caps you are comfortable having in your contract.
Thanks, Tom. And then finally, we've got what I call a scoop all, every other loss or damage being limited to an amount. And again, I would be saying, well, actually, is that a per claim? Is it per annum? Is it total aggregate over the life of the contract? And then the final observation I would be making with the supplier on this clause is the fact that there isn't any sort of what we might call a consequential losses exclusion. So there isn't any sort of exclusion for loss of profit, loss of damage to business, damage to goodwill, and so on. So the question I would be asking the supplier is, do you mind what category head of loss you're picking up, so long as it is subject to Lim C? Or are there heads of loss which you would not want to have liability for in any circumstances? So that's my final observation on clause 2.2. So that brings us to the end of our example clause. Thank you for that, Tom. Let's just take a look very quickly at questions. Interesting question here, Tom, is how would insurance view a claim from the US exclude, there's a bracket excluded, which has arisen from someone in the supply chain taking, I think, a product or a service to the US without your knowledge?
Yeah, no, it's a good question. I mean, if it's the insurance, well, insurance doesn't really care whether the claim is a good one. So if someone else within the supply chain has effectively taken steps in the US that renders a liability for you, if you have a defense to that because you didn't know about it or for whatever grounds, I mean, that's a litigation defense. It will not change the position under the insurance, which is likely, again, different provisions in different types of policies, but assuming that it responds on where the claim is made, that is effectively a trigger to cover or an exclusion, let's say. So if the litigation is in the US, then it doesn't really matter what's alleged, it's going to be excluded.
Okay. Thank you. There is also a question around the limit of liability clause not capturing indemnities in the contract. So quite often we will see indemnities peppered throughout a contract, and we would be looking as a matter of good practice to bring those indemnities if they exist elsewhere in the contract, within the scope of the limits of liability. But the question is how does that sit with insurance cover? Now, Tom, my understanding has always been just because you give an indemnity in a contract does not mean that that will be covered by insurance. It is my understanding right? So I always warn people, actually, you should assume that an indemnity you give will not, all of the claim would not be covered by insurance.
That's correct. Again, it goes to that principle of contractual only liabilities. I mean, there is obviously an exception in warranties and indemnities insurance, which the label itself suggests otherwise, but that's very specific to corporate merger and acquisition activity. That's one of the few kind of times where insurance effectively is aligned with, in that case, SPAs, so purchase agreements, and aligned with contractual terms and indemnities provided.
Okay. Somebody's asked for a very brief word on talking through claims arising versus claims made, Tom?
I mean, it's I think I'm happy to speak with the person asking that question just for a bit more context. But you've got, I mean, certainly you've got one sort of group of policies that one might call occurrence-based, that respond to incidents that happen, so losses that arise during the policy period. So, for example, if your factory burns down during the policy period, then it is that policy that will respond to that loss of your factory. And that tends to be around what we call first-party insurance. So it doesn't rely upon a third party making a claim. It's a personal loss to you. Same with crime losses, for instance, when if the employee is stealing, when you discover that, that's an incident. And that might be what means about a sort of claim arising. The other group of policies is claims made, which effectively respond at the time that a claim is made. So it might be that 2 years beforehand, you provided some design services for the installation of a security system, and then it turns out that it failed. Intruders got in, ransacked, customers suffered losses, and they bring a claim. And it's the policy in existence at the time that the claim is made that responds, not the policy that might have been in existence when you provided those initial design services.
Thank you. There's an interesting interpretation point here about if you have a separate insurance clause and a separate liability clause, as per our example, if there was a dispute, could the insurance limits override the stated cap? Now, I think that is it's a matter of construction, and it's a matter of intent, and it's a matter of looking at the contract as a whole. I think in the example we've given, that sort of requirement for an additional insured actually would take you outside of the limits of liability if you were to accept that, because why would you accept it if the customer couldn't claim to those limits? So I think the answer is it really is a matter of construction, and in an ideal world, you, for example, the references to liabilities under the agreement in that clause creates an ambiguity which we would want to get rid of. The ideal would be to say, actually, the insurance is the insurance, but it is without prejudice to the limits of liability, i.e. they override. But I think there's a subtle question of construction and interpretation when you look at the agreement as a whole and what the insurance clause is covering. So, for example, it isn't unusual to see a requirement that somebody must have public liability insurance. That's a matter of doing business, and people want assurances on that. And quite often they will ask to see the evidence of that during a tender process. Just one final point before we close. I'm conscious we are running out of time, and I can see people dropping off. Somebody's asked about our thoughts on providing insurance documents for larger contracts, placing the customer on notice of the cover you have with the option of expanding at their cost on request for a particular project. And yes, I think the answer is I see that quite a bit when people are responding to tenders. This is the insurance we have. If you require more, then you need to tell us, and there is an additional cost. So I think that really is a sort of commercial sort of to and fro, but it's something that I see quite a lot in tender responses. And actually quite often the sort of insurance evidence is included in an annex for large projects. Anything else from you, Tom, on that?
No. I think it's a matter of choice, issues of confidentiality, what you're happy to disclose on a limited basis. But yeah, it makes sense. Certainly, I've seen situations where counterparties effectively kind of group together the insurance to make sure that each aspect of their relationship is covered one way or another.
Okay, thank you for that. Thank you all for joining. And sorry we've run over by a minute. A feedback screen is going to appear in a moment, so please do give us your feedback so that we can frame our program of events for you and make sure we're covering topics that you are interested in. Thank you very much for joining this morning. Thank you for your active participation with all of the questions. Thank you, Tom, for your insights. Thank you to Kate and Christine behind the scenes who make sure this all works and runs smoothly. So have a good day, everybody. Bye-bye now.